Any mention?
Yes. Okay. I'd like to make a mention of item 19 of the hearing list, my lord, of the main list. It is taken up next week.
19?
19, my lord.
Where's the petitioner?
Lordship. Here, Lordship.
Yeah, or strong objection? No.
Next week. Next week. He said next week.
Okay, 2 weeks is
Lordship.
on the prayer of Mr. K.P. Bhattacharjee for state respondents, yes.
My lord, here I am for the private respondents, my lord.
Private respondent. Okay. For this private respondent.
All right.
What's first?
May I please, Your Lordship, I'd like to make a mention on part 2 of the hearing list, item not 20, Your Lordship. In this case, I'm a little handicapped. I mean, like, I have some personal difficulty.
When I have taken consent that AG would be available, then only I have come, my lord.
I'm yet to get the instruction with regard to the cabinet decision that 15th March 2023 with regard to the regularization of the petition.
That is there on record. I have given the order to your lordship.
What's the matter about? I've forgotten completely what you submit. I can't recollect what is the matter about?
First, there are two cases.
Proceeding, Your Lordship.
One is regarding regularization. He has completed 34 years of service. Now they are saying they are ad hoc. Therefore, no regularization. Now, in the meantime, there is a cabinet decision saying that all those appointed, they will be regularized. That order I have handed over. They want to take instruction on that in last occasion also and this occasion also. Second is regarding departmental proceeding. They have not followed any norms, my lord. It was behind my back, no inquiry report, nothing, my lord. My lord, petitioner is in ventilation, my lord. He has no chance of surviving. Today or tomorrow it will be removed, my lord.
Just see the file.
It is grave urgency in the matter, my lord.
Yes?
It is grave urgency in the matter, my lord.
All matters are urgent. For every person who comes to court, his case is the most important thing to him, the whole world. So courts also look at that way. For every person who comes, for him it's the whole world. This case is the most important thing for him. Yes, why is adjourn this time? You're supposed to produce the original records.
Yes, Your Lordship.
Today. Have you brought them?
Record, it's with me, yes, Your Lordship. Apart from that, I need that instruction part. I'm a little handicapped. I'm yet to receive the instruction.
I have given a detailed written submission also.
Because coming from you is fine. He has to get that corroboration. I mean, we'll give him one more large opportunity.
Yes, Your Lordship.
We'll pay him cost.
Accommodating is not a problem, my lord. Yesterday evening I have taken consent that say that he will be available. That's why I have come.
You called him on the phone?
No. I have taken instruction from him, my lord. He has said that AG will be available, my lord.
Oh, AG?
AG will be available online, my lord. That's why I have come, my lord. No, morning only.
Then you pay him lunch money and taxi money. When should we have it? You give a date. You're not adjourning it any further.
Yes. Any that as part of the
otherwise, if we finish your submissions.
I can finish. Already your lordship has heard. Lordship will remember everything. I've given submission. So that way, my lord, only record may be consulted and lordship may. I have nothing to submit further, my lord. Your lordship has heard the matter extensively, my lord.
A short date may be given to as part of the convening of this honorable court and subject to the date fixed.
Okay, give one more date. If you don't come, also
some observation, my lord.
Yes.
The matter has been fixed today for further hearing and for production of all the records by the state respondents. Mr. H. Abraham today expresses his praise for some accommodation due to the fact that he could not obtain specific instructions with regard to regularization of the petitioner. Those strong objections have been raised in the interest of justice. Fix this matter on so and so. You take a date for court master, which is convenient. Yes. That's item number 20.
20 and 21 connected, Your Lordship.
Yes, matter. We finish it. If it's already been argued, the source said that we don't want to keep it pending. Yes.
I have pleasure.
Should I like to mention item 22, my lord? But the state of Assam was also party. They had informed that they will not be available today.
What the matter about?
It's regarding the death of the petitioner's son at Nepal. Lord.
At Nepal?
Lord. Praying for a week's time, my lord.
You're for the petitioner? Lord. After 1 week, yes.
Obliged,
Lord. Main list, item number 1.
My lord, I have to for some time.
What?
This item number 1.
Where's my Changreso?
He's not available today, my lord. Can you accommodate for today, my lord?
This is, see, you've sought time yourself last occasion also. What's the matter about?
This is the clubbing together of the Mausau Mini and Mausau village. We agree with the impunge order of the KCDC, my lord.
Derecognition or recognition?
Derecognition.
Derecognition of which village?
Mausau Mini village.
On what grounds it depends to recognize you? Where's the impunge order?
What the impunge order is?
Mr. Kintas here.
Lordship is on his way, Lordship.
On his way where?
Lordship is on his way, Lordship is almost here.
Or on way to
Stuck in
court?
traffic. Yes, Lord.
Okay.
So kindly accommodate for today, lordship. Page 264, my lord.
Yes. See, it records that you all were heard and both of Mausau village and Mausau Mingi village jointly met, collectively decided to merge the village into one. Now who are you? Are you the Sultan? Who's coming before the court?
Lordship.
Who's the petitioner for the court? Village another. Let's see who represents the village. Sri Throbbing Star long line.
Soda.
Yes. On the prayer made by Mr. Sunso, this is matter due to unavailability of senior arguing counsel. This is matter up to 1 week for admission hearing. Yes.
1 week or
Yes.
oblige.
Item number 2.
Oblige, lordship.
May it please your lordship. Lordship, may I just point out the order dated 7/8/2023.
Yes, matter has been resolved.
No, Lord.
Please, Your Lordship, I'm praying if this matter for Passover and will be taken up after some time.
Item number 3.
Yes, Mr. Pasanti.
Your Lordship, we filed a affidavit of service bringing on factum of the
Number 5
record.
has been served.
Yes.
Number 5 has been served.
As per the status report, Your Honor, Your Lordship, it has been delivered, Your Honor.
You filed service affidavit.
Yes, Your Lordship.
Your Lordship, in my humble submission, respondent 5 here is represented by the Ministry of Road Transport and Highways, and nothing up till date we've not been intimidated by the office up till now regarding this matter. So if I may be allowed some time to have instructions.
You'll be appearing for them.
Most likely, Your Lordship.
Yes. Mr. P. Pastor submits that after service has been filed indicating the factum of service upon number 5 star. MS next MS from Thao, Vice of Administrator, who would be entering appearance on 5 submits that they are yet to receive instructions. What about affidavit by the state?
Your Lordship, state has filed affidavit.
Already filed.
Yes, Your Lordship.
She prays funds allowed 3 weeks time to obtain instructions and to file affidavit. This thereafter and so on. So.
Obliged, Your Lordship.
This acquisition.
Your Lordship is compensation of bills, Your Lordship.
Item number 4.
My lord, as per the last order, my lord, we are filing the affidavit. We have served the copy, my lord.
Just
I've just served, my lord. There is some type of
Just
error.
now I
We are
received.
correcting and we are
It's half
serving.
an hour.
just now received. May I please, Your Lordship?
Half an hour.
1 second. So you're appearing for 5 and 4 and 5?
For your private respondent.
4 and 5?
5, Lordship.
5.
But
What
the
do you
matter
want?
has gone ex parte, Your Lordship, as per
Against
the
five?
last order against 4 and 5.
Oh yes. So you're not in the running anymore. We can hear submissions on law at time finally hearing, that's all.
But I can come up day after tomorrow, my lord.
Yes. Mr. S. D. Leonard Council 123 submits that the affidavit has been filed.
No, my lord. It's on the process of filing. We have served them the copy.
Filed. It's being filed in the course of the day's term. Ms. Ipek Harsono appraised that the matter be listed after
1
week. Yes.
Hello.
If you want to be heard, you file anyway. You know what to do. What should the court advise?
Item number 5.
Yes.
Your Lordship, I'm appearing on behalf of respondent number 2. I'm already filed my affidavit in opposition.
Yesterday, Your Lordship.
So what do you want now? For rejoinder or no?
Yes, Your Lordship, I pray for.
One?
Your Lordship, I don't think we have a role in this matter, Your Lordship.
Is regarding that limitation?
It's a private dispute, Your Lordship, between the landlord and the tenant.
Oh, why by rent petition?
Rent depositing, Your Lordship.
Rent deposit?
Yes, Your Lordship.
You want to file a rejoinder or necessary?
I will file a rejoinder the next day, Your Lordship.
MSC first for number 2 also. Some is have been filed sub. Also on behalf of the pressure praise funds or 2 weeks time to file a rejoinder. Just thereafter also.
Give leave, Lordship.
Item number 6.
Lordship, the state has filed its reply.
Yeah?
The state has filed its affidavit in reply.
We have not received any.
We have,
I'll check it out.
I had served it on you.
Instructed by that. I'll take it out.
Yes, office note dated 25/8/2023 indicates that after opposition behalf respondents 1, 2, 5 and 6 have been filed. Though Mr. S. Definitely, however, petitioner submits that he has not received a copy of the same. This is matter after 2 weeks for rejoinder of any.
Acknowledged. 7.
Your Lordship, in this case, the government has filed their affidavit.
You're supposed for rejoinder within 3 weeks.
We have filed also a rejoinder yesterday. My only contention, my Lord, Your Lordship will peruse the affidavit filed by the government is more or less like a thesis of a postgraduate student. They have maintained that it's not maintainable and all that. But our main grievance, as per the writ petition, my Lord, is that nothing has been done by the state government in respect of the FIR, which was filed by the children of the deceased.
Where's the rejoinder?
Rejoinder we have filed.
Yes.
Now, there's no answer to the paragraphs number 4, number 5, number 6, number 7 of our petition.
No, you are submitting that it's on the FIR of the children.
Yes, we have filed an FIR. My Lord will come to para 8 of the writ petition, page 6. Here we have stated the respondent number 3 forwarded the FIR filed by the son.
No, but the FIR was the children not called for the commission of inquiry to tender evidence.
No, they have given evidence during the inquiry. But this was
recommendations are there regarding excessive force.
Recommendations are different.
Are you here for the FIR or are you here for that some action?
The episode, yes. And what action has been taken, because they have registered a case, Maulai PS case number 44, dated.
Have they said what's the status of this case?
No, they were completely silent. So my prayer is that the CD should be called for, so that we will know what is the stage of the case.
Who's the paying for the state?
Learned Advocate General is leading the matter.
Where is he?
Lordship. He's currently not available.
Yes, currently unavailable. That's a very convenient answer. So we are free to pass whatever orders, unrebutted by the state. Is that your submission?
If a short date may be given, Lordship.
Mr. So-and-so, the council will submit the joint affidavit. You filed it on?
Yeah, yesterday.
It's been filed. You have received a copy?
Yes, I received.
And a copy of the seal has been served to the respondents. He has ever flagged, he has ever raised, he has ever submitted that the affidavit filed by the state respondents has not addressed the averments or statements which have been made in the petition, especially with regard to the FIR registered, the case which is registered as Mola IPS case
number 44
dated 18/8/2021. Stop. Next, Mr. E.R. Khan, correct?
Yes, sir.
Submits that he is handicapped as the Advocate General, being the matter is not available at the moment. He plays a short date be given. Now, this is matter we listed when? At least that's indicated there in the, if you can come with instructions,
yes,
whatever. When?
After a week or two.
This is matter after a week. It's expected next day the Advocate General will be ready with instructions as to the status of the case. IPS case 44.
Much obliged.
Item number 8.
May it please your Lordship. Lordship, we have filed our rejoinder. Lordship, in this case, we are being led by our senior Mr. K.N. Chaudhary. I humbly pray that a date may be given for final hearing, Lordship.
I was asking how much cost you want to pay.
Lordship, after hearing Lordship, whatever Lordship
deems fit. Put on the shoulders of your learned senior.
And I have also filed a miscase also, Lordship, to cure that thing, Lordship, for 65B, along with the petition, this was to be, this certificate should have been there. To cure that defect, Lordship, I have filed a miscase.
This certificate is not in proper form, also, your Lordship.
What certificate?
Actually,
it should be under section 65B of the Evidence Act, your Lordship. When any digital or electronic evidence is sought to be introduced, certain conditions have to be fulfilled, which has not been done, your Lordship. It's just a miscellaneous application, not a certificate.
Lordship, actually, what has happened is this, that in general cases, the police files the this certificate. But here, Lordship, since I have secondary to sanctify this secondary evidence, Lordship, and to cure that defect, Lordship, I have filed this miscase.
This miscase is liable to be rejected.
So whatever report the...
This is on the 7th of May of...
Sorry?
The incident occurred on 7th of May.
5th of
July,
5th of July.
5th of July.
5th of July.
What miscase is there?
Miscase number, I don't know, Lordship. Today morning we have filed it. Lordship, I just prayed that a forensic analysis may be done for this CD, so that will be considered as a certificate, Lordship.
We'll consider your senior come.
Lordship. 18th of September, may I pray for it? For final hearing, Lordship.
The joint affidavit been filed on behalf of the writ petition today has also miscased up.
I'd also like to file my affidavit.
Yes, this is the matter after. Now it's after 3 weeks for reply to the miscase, for objection to the miscase, and for further orders.
Lordship.
Yes.
Pleasure.
Deeply obliged, Lordship.
Item number 9.
Please, Your Lordship. My Lord, service of respondent number 4 to 14 to 17, my Lord, has been duly served.
All been served?
Already served, my Lord.
How many respondents are there?
17, my Lord.
70?
Oh, 17.
Lordship, I'm entering evidence on behalf of respondent 4 to 17.
Louder.
Your Lordship, I'm entering appearance on behalf of respondent 4 to 17.
Very good. MSE Wanyang has entered appearance today on behalf of respondents 4 to 17. So such the service is complete. Yes, when are you filing affidavit?
We are waiting for instruction.
So it's MS, SI and GF 123. Praise for how much time?
2 weeks.
What about you?
I'm also praying for 2 weeks' time, Your Lordship.
And Ivania on behalf of Forest Navy for 417, pray for and allow 2 weeks time to file affidavits. This thereafter.
Item number 10.
Who filed affidavit today?
Lordship, we have filed respondent number 3.
You receive a copy?
Yes, Lordship. Just received today only.
Yes. What do you want today?
Lordship, if Lordship will grant me some time, Lordship, because I'll file a reply to the affidavit that
So
they
just
have
for
filed.
second time it's come.
Second time, Lordship. This,
An affidavit on behalf of respondent number 3 as Power Grid.
Power Grid.
Has been filed today itself. Stop. What about 4 and 5?
Lordship, I still haven't received instructions yet, Lordship. I pray for some more time to file my affidavit.
Yes, Mr. Angumno? Please stop, Mr. E.H. Karwanlang on behalf of respondents number 4 and 5.
4 and 5, Lordship.
Yes. Praise that you have allowed how much time?
Lordship, 2 weeks time.
2 weeks time for affidavit stop. Just up to 2 weeks for affidavit by 3 and 4 and 5 for rejoinder, if any.
If any,
affidavit
Lordship.
filed by respondent number 3 by the petitioner. Yes.
Obliged.
Item 11.
Who's the petitioner matter? You or nowadays panel up to appear in one case? Since when is this practice started? Actually, one case is assigned to one panel lawyer. So the billing double. That's a very strange thing. If I can answer the senior counsel appearing, if you appear, the whole matter will start getting stalled in.
No.
Yes. Yes.
yes, Lordship, they have filed the affidavit, Lordship.
Yes.
And Lordship will see the affidavit, Lordship. If Lordship will go to the page, annexure 4, page 14, Lordship. I apologize, Lordship. Let me take first to annexure 1, Lordship, of the page 9. That is the complaint filed by one Srimati Agnes Kharshe. Lordship, the petitioner here in Lordship, he was not aware of this complaint also, Lordship, of this FIR, Lordship. Only when we received this copy today on their affidavit, Lordship, then when inquired, he was not aware of this also, Lordship. The authorities, the police, they had just come to verify in his house about the papers. They had asked him about the papers.
When was this complaint?
Lordship, this complaint was from 2013, 22nd January 2013, Lordship.
Highly unconstitutional. So you should annex this electoral roll also.
Yes.
Yes. And what else you want to show?
Now, Lordship will see again in that, I go to that annexure 4 of the page 14, Lordship. Now, Lordship, in this there is a communication only between the Deputy Commissioner and the Additional Deputy Commissioner, Lordship. This is with regard...
Next, you just read it. This is 14 is from the police to the DC.
Yes, Lordship. So this is a communication, Lordship, where they have interacted, but I am not aware of this complaint also of the FIR, Lordship, because the only thing that they did is they inquired me about my papers and all my documents, Lordship, which I had given to them
It's
to
not
verify.
FIR, it's just a communication.
Yes, Lordship. The
But
first was
PS case, but the case registered under, can't make out also section.
under
What is this?
Rinja PS case 117/198/419 IPC, Lordship.
Then commission not traceable.
Yes, Lordship.
Then after that,
Lordship, then these are the only the communications. They also annexed the same annexure that we had already annexed after losing my ST certificate, Lordship. I had filed a missing report. Then this is the report that they had annexed, and which we also had annexed in our petition, Lordship. That is the same. So, and Lordship will see. Now they are coming in their affidavit saying, Lordship, they said that.
now what's the status of the case then?
Lordship,
It's after 2013. See, in 14 March 2013, this is communicated from SI to, or it's from Deputy Commissioner.
From 2013, Lordship. They say that there is the case is proceeding, but nothing has happened.
So there are no records of the issuance of the shelter certificate also?
The ST certificate was issued much earlier in
1982.
Correct, but the Deputy Commissioner's office, there's no records at all. So my certificate issued maybe in 1990 or 1980s, whatever, they won't have a copy. They don't have a register to show what is registered or not.
My lord, it is 98. They should have a record, my lord.
Then?
Perhaps somewhere in the...
Then the affidavit does not answer anything?
Well, the affidavit says that, my lord...
Not traceable means what?
The petitioner...
There's no register or issuance register with regard to shell type certificates.
No, it has to be there, my lord.
Then?
But my respectful submission...
What do you see in affidavit with regard to the records not being traced?
My lord, in the affidavit we are saying, my lord, that neither the petitioner's father is a tribal...
No, forget about that. Where you issued once. The vested rights accrue to the petitioner, whatever it is. You have issued a shell type certificate once. Now he has the right to know what's happened to it. Whatever proceedings you have later on, that's your lookout. But the thing is that now you deny him, now you bring up the case, you can't trace the records also.
Lordship,
it's not satisfactory.
Lordship, now...
Whatever it is, if he didn't have anything, we can understand. If he's asked for a issuance schedule certificate, he didn't have schedule certificate before, by saying that, okay, fine, he's a scheduled tribe, and you reject on the ground that is well and good. Or is a complaint, fine, that you record it, well and good. Nothing was done. The proceedings were initiated on the complaint of some third party. He was never made aware of them. And now you don't issue duplicate, and when she's asking for that, or he's asking for that, there's no record.
The fact, my lord, that some verification was done. The police had approached...
Verification, but where are the records? That means the only document present is for a photocopy of the original that he had.
So 98 file, my lord, that is why. Otherwise, we have stated in, of course, in para 9, my lord, that that they have an endeavor was made, but the file could not be located.
Endeavor mean what?
To no avail. In this regard, same was accordingly intimated to the in charge Nongtumai police. White letter dated. Annexure 5.
So the case been closed, and an FR. What happened to the case?
Final outcome of the case will not
Then?
be available.
This case registered in 6-1.
Not only the police will be able to answer. Will be able to answer.
You are the authority. What do you police answer? It's your job to go find out what happened to the case. If it's before the court, it's very unsatisfactory. Take down, and after it's been filed on behalf of the respondents 1, 2, 3. So a perusal of the same indicates that in the year on 29/1/2013, a complaint had been lodged before the additional SP crime that the petitioner had been impersonating and was using the Shell Tribe certificate of Nongrum and cheating the Khasi people, Perki Nongrum clan. Stop. It appears that on the basis of this complaint, Rinja PS case 6/03 under section 117/198/49 IPC was registered, and the investigating officer at a point of time had sought the required documents from the Deputy Commissioner. He's the respondent number?
Respondent number 2.
Respondent number 2, stop. By a reply dated 14 March 2013, the respondent number 2 informed the investigating officer that the papers connected to issuance of Shell Tribe certificate in respect of the petitioner was not traceable. Stop. Apart from these materials have been placed on record, nothing else has been forthcoming to the respondents as to any further reason for non-issuance of duplicate Shell Tribe certificate. Stop. And therefore directed to which date is your Shell Tribe certificate? Where is it?
31st Lordship, that is true.
There's a register number, correct? Which page is it?
Lordship, this is an annexure to page 13 of my petition, Lordship.
Another aspect is whether that certificate is genuine or not.
Very good.
Then, Lordship, may I also say on that, Lordship?
Yes.
Lordship,
Thomas?
Apart from this, nothing else was forthcoming from respondent as to any further reason for the non-issue of certificate.
Stop. The Shell Tribe certificate or petitioner photocopy whereof has been annexed to the petition, and the same has been issued from book number 117 with bearing serial number 11616 dated under 1616 with issuance number being P stop 15/9/83/11616 dated 12 May 1983. Stop. The state respondents are directed to produce the said book number on the next date positively. Book 117, the seal number will be different anyway. Stop. List after 1 week.
But may have to put 2 weeks. In the meantime, we'll ascertain the.
You see, if it's any issuance by any, it's like losing a pata. If issued from a revenue authority or from an authority issued certificate, the book number is there. Now it's so simple to say not traceable.
So, not another aspect. This is one aspect, Madam. Another thing is that regarding the police case, we will also ascertain, Madam, what is the current status.
Not an FR by now.
Lordship, within
learned government advocates also volunteered to obtain the status of the police case mentioned above and to apprise the court about its status. Stop. In the meantime, as the petitioner is to superannuate on 31st of
this month, Lordship.
Notwithstanding the pendency of the proceeding for this court, the pension papers as entitled should be processed. Yes. Just after 1 week.
Highly obliged, Lordship.
Hearing supplementary list item number 1.
You'll have to do that. No.
this is that matter where the written statement was closed, and also
yes,
at the
I
same
remember.
time.
Paragraph 2001 6 volume, 2001 volume 6 SEC. Where was the Paul?
He's on his legs, my lord, in the DB, before the DB, my lord.
Did you have any further submissions to make?
But he was. Mr. Paul was. Perhaps he had some submissions to make before the general.
Which he didn't divulge to you. What submissions he had?
No.
Great secret.
Not exactly, my lord, but yesterday he wanted to come for this matter, my lord, but he has in fact directed us to, with Lordship's permission,
to stall the court.
To keep it at the end of the board, my lord. If your Lordship so pleases, may kindly have it at the end of the board. Otherwise, my lord is aware that the issue which we are urging before your Lordship is very limited.
You come to 227?
Yes, my lord. You have come by way of 227.
We'll pass orders then.
My lord,
Anything
may kindly
else?
have it at the bottom of the list. My lord, may kindly hear Mr. Paul once and
okay,
since
after some time.
Yes. Obliged.
Main list. Item 12.
Yes.
These are all the connected matters
Yes.
concerning Kheta Dua.
Okay. Last occasion we had submitted the report before this honorable court.
It flagged it, correct?
Your Lordship had fixed the matter for hearing. Your Lordship had
Yes.
directed that come
Pagination.
prepared for hearing. My
Yes.
humble prayer is, my Lord, if a copy of the report could be provided, because if there is anything against us, then we may be allowed to answer or file an affidavit with regard to
Why are you very apprehensive about your
No, my lord, your
complicity
lordship
and your
has-
culpability
your lordship has
with regard to
stated-
the entire?
Not, my Lord, I am not apprehensive, but your Lordship had indicated on the last occasion that there is something. That is why if there is anything, we may be allowed to reply to it.
What do you say, Mr. Barsali?
My lord.
Should you give him a copy of the report?
My lord, I have my reservations, my lord, because when the inquiry was initiated, my lord, they were all allowed to participate.
I don't have any such request, my lord, because it will never
It's
end.
not a case
Lordship
that
will
they were
see
not
the
allowed to
first
participate.
matter is of 2017. Finally, we have come to
My lord, they were heard.
some sort of, my lord, progress. Again, if affidavits and reply, and it will not.
No need for a report. Yes.
Just keep it, just say that pagination, we'll just compare the court copy and our copy. The court says matter ends.
Okay. See, one thing, just all of you had taken part in inquiry, correct? All of you had submitted your documents or whatever. Then that's enough. Not that you're not heard. The inquiry be reflected in the order.
In case something comes, they can, whoever is aggrieved can, my lord, take it up.
See, once what Mr. Dev says correct also. Once we start giving copies of inquiry around, then you will start you want to pray for an affidavit against the findings. That will come later. Now the findings are already here. You've been heard. Now were the proceedings irregular in an inquiry? Were you not heard?
Whatever is there, my lord, in the inquiry report, at least we have the right even to know.
Of course you'll know. Once the order comes out, you'll know. In black and white it'll be there. In black and white it'll be there as to what you have done.
If anything adverse is reflected in the inquiry report, my lord, at least we should have a copy, my lord, of it. So that we'll be able to go through.
After we go through, what will happen, Mr. Sinhan?
We'll see, my lord, if after going through only, my lord, we come to any conclusion.
What conclusion? The court has to come to conclusion, not you. You have finished. Your part is over.
If required, my lord,
Your part is over. Your part is over. Is that for the court to be able to appreciate the entire matter, because it became such a hodgepodge. That's why inquiry was called, asked with them recommendations get through. Now he's done an inquiry. He had one stage, second stage, third stage. He's done. All of you have cooperated. Very good. You've taken part in inquiry.
In fact, my lord,
the inquiry report.
Petitioners had earlier agreed, my lord, that this honourable court will order for an inquiry, and based on the report, this honourable court will come to a finding.
Yes.
Now that cannot be the absolute truth. Whatever has been reflected in the inquiry report, my lord. We after going through, my lord, there may be something which we would like to challenge.
You are appearing for whom? What's the name of your?
Appearing for
Okay, that's why you agree. Because you are a culprit in the entire sequence of events.
That
No,
is,
my lord. In fact,
before-
he is the founder
Before
teacher.
my lord hears the entire matter, my lord have already came into a conclusion that my
Who has come to conclusion?
my lord has already.
No. I'm just reading what is said here. You're going to balance all your rights and your and your claim counter claim. It's not a question. I'm saying what is. See.
In fact, my lord, the rejoinder which was filed in WPC 264 of 2020, that was extremely elaborate, providing all the documents, providing all
Who
the
filed the
details.
reply?
My lord, I had filed a reply.
Yes.
With all the documents, annexures, my lord, against one person, 6 reports are in the positive. Only 1 report is in the negative. Why is that so? 6 reports cannot be in the negative.
My lord, if I may
The
submit.
state has a role in this entire whatever has happened, my lord. State has a role. Now they want to wash their hands.
No one's gonna get any.
And my lord, I'm not on the reports filed by the state. I am on the certificates issued by the respective institutions from where the petitioner has done his courses.
Very good.
My lord, in fact, in the earlier round, my lord, there was a full-length hearing, and only thereafter, my lord, this honourable court decided that there should
No,
be.
we are aware, Mr. Bharti. Let them make the submissions. Let them air the grievances. We'll pass orders accordingly. That's all. If you agree, you can appeal. No problem. This order will be tested. No, this is not the end. Mr. Bharati, his headline, he's already highlighted the important parts also.
He'll highlight, my lord, the
Yes.
points which is in the favor of the state. Not the entire report.
Then make a submission. What do you have to say?
Without report,
We're not doing the report right now.
Proceedings are concerned, the hearing has already been taken place, my lord.
Okay. Then we'll pass orders. We'll reserve for judgment.
In fact, on 1st of February, the matter was already reserved for judgment,
Yes.
and then it was again.
We can do one thing. Now this is Nazila Begum, Nurul Amin, Join Ali, Shoguza Begum, then managing committee. Then, okay. What is your nexus with Ila Begum?
No nexus, my lord.
No nexus.
No, my lord.
Absolutely.
No nexus.
Yes.
In fact, my lord, in WPC 264, we have challenged the appointment of Shoguza Begum because the managing committee which had appointed her as a teacher in the school all the members, out of all the members of the managing committee, majority of the members were her family members, and no advertisement was issued for filling up the post, my lord. Husband was also a member of the managing committee. Father-in-law was also a member of the managing committee. All the relatives were the members of the managing committee who were.
Grandfather he was member also. The grandfather? No. You say whole family members?
But whoever
Yes.
were a part of the managing committee, majority of them were family members,
Yes.
including the husband. And no advertisement was floated. It's a public post. An
Yes.
advertisement ought to have been floated, giving opportunity to all candidates to apply for the post. But nothing of this sort was done.
Yes.
It was a direct appointment by the managing committee.
Yes. We'll direct henceforth all vacancies to be advertised. All eligible candidates to be selected, called for test and interview.
He gave NOC when I was appointed.
No, my lord. That NOC is absolutely
NOC for?
For my appointment.
My lord.
Without selection.
It was a that was the practice. I don't want to, that was way back in 2012. my lord.
My lord, that was in the affidavit.
Yes,
of
Ms.
opposition
Agarwal.
they raised,
Yes.
but we had opposed it. We are completely denying that fact. There was no NOC taken from Nurul Amin.
And she was the only one who was qualified at that point of time.
Who?
The Shobuza. my lord.
Not
You're
without
for-
advertisement, how can we know whether others are qualified or not?
Yes.
There are so many people in the village, my lord. Not just Shobuza Begum.
Who?
Not just Shobuza Begum, my lord. There are many other people in the village. We don't know whether somebody is qualified or not qualified.
Yeah, Nurul Amin, both of you. Nurul Amin.
Yes, ma'am.
Very good.
He has engaged us in separate cases, my lord.
Doesn't trust one of you in one case. Yes. Okay, here, which one did you hear first last time? One, when we had notes, which one? Oh, I see notes here then. Which one? The reserve judgment. What is the last order? Yes, matters taken up today for hearing, as the same is substantially heard on the last occasion. The matter, judgment reserved. Here is concluded. Judgment reserved, please.
23. 23.
Yes.
Lord, this is a matter pertaining to appointment of the petitioner in Assam Rifles. But basically, the Assam Rifles had introduced a recruitment rally in 2017 and 18 for the post of rifleman. The petitioner had applied for the said post, and all the documents were submitted at the time of submitting the application. Subsequently, my lord, he was called to, his examinations were taken and he cleared both the examinations. Thereafter, he was called to Shillong, the headquarters, because there was some discrepancy with regard to domicile certificate. If your lordship kindly takes up page 27. Page 27, serial number 23.
Yes.
My lord, this is the list of not selected candidates due to reasons mentioned against each. So, serial number 23, Hiralal Shah, he had applied from the state of Nagaland. Result held up due to suspected domicile certificate. My lord, the only reason was domicile certificate. That is why he was called to the headquarters on 20th of 8, 2018 along with the original documents. He appeared before the officers concerned at Assam Rifles Light Corps on the said date, and he produced all the certificates which were available with him. Thereafter, my lord, the respondent simply asked him to bring a certificate from the deputy commissioner, and accordingly the petitioner applied for a certificate from the deputy commissioner of Dimapur. Now, on behalf of the deputy commissioner, the divisional officer Sadar had issued a certificate on 24/8/2018, certifying that certificate issued by deputy commissioner. Previously, a certificate had already been issued by the deputy commissioner, which is at page number 31. Page 31, it is a certificate issued by the Deputy Commissioner regarding his residence, my lord. And he had also submitted his permanent residential certificate, his voter ID, etc. But he was not given appointment, my lord. A supplementary list had come out, which is at Annexure G, my lord, at page 36, serial number 4. Page 36, serial number 4.
Not selected.
Requisite documents not found in order. He was not selected. Now, my lord, thereafter, the petitioner had issued a legal notice as to why appointment is not being granted despite all the documents being in order. My lord, no response was received. Thereafter, my lord, in the year 2021-22, again another recruitment rally.
2018, when we come to court first?
Yes. This is the first round of litigation, my lord, and I'll satisfy your lordship on the delay part as well, because this had come up at the motion stage, my lord. But before I go to the delay and laches part, my lord, if I may just clarify why it is at this stage that we have come before this honorable court. Lord, another recruitment rally was held in 2021-22. In this particular rally also, my lord, a lady from Nagaland had applied for the post. My lord, the list of candidates is at Annexure J, page 44, and the candidate's name shows at serial number 16 at page 47. This is the select list.
Okay.
Page 47, serial number 16.
16.
Yes, my lord, 16. Name is Asha Thapa. Documentation was pending, but subsequently she has been appointed, my lord. Now, the permanent residential certificate submitted by her is absolutely the same as what was submitted by the petitioner, and the certificate issued by the deputy commissioner with respect to Miss Asha Thapa is also the same as was issued with regard to the petitioner.
My lord, on the basis of the same documents, this candidate has been given appointment.
So come to court earlier.
My lord, in 22 itself we have come. The recruitment rally was of 2021-22.
No, your recruitment happened when?
My lord, I'll satisfy on that as well. That was in 2017-18.
No, you slept on your
Then a
rights.
legal notice was sent, my lord. Thereafter, the brother of the petitioner was suffering from, first the mother was suffering, Malari Devi. She expired on 1/10/2019 after long illness at Railway Hospital, Lumding, in which, my lord, substantial amount of money was spent. And the petitioner herein is
So why
merely
did
a
they say
fish
it's
farmer.
not genuine, the certificate?
Your Lordship, it's not the fact that it was not genuine. The only ground was that it was found to be suspicious, which is why the petitioner herein was called by letter dated 26/7/2018, Your Lordship. And that's where the petitioner reported, Your Lordship, just a minute. The petitioner had reported at the Headquarters Director General, Assam Rifles, on 28/8/2018, whereby he failed to submit the requisite documents, and that way an undertaking certificate was also signed, Your Lordship, and acknowledged by the petitioner, which is given in Annexure 1 of our affidavit.
With regard to the undertaking certificate, my lord, I have a categorical response made in the affidavit in reply. Now, with regard to the undertaking, the respondents have taken the stand at paragraph number 5. Not only 5, my lord, before that they have also made a mention at paragraph 2C. So if I may take your lordship to paragraph 5 of my affidavit in reply.
Okay.
That with regard to the statement made in paragraph 2C, it is stated that the petitioner did not fail to submit the requisite documents as stated by the respondent, but in fact he submitted all the requisite and genuine documents before the authority concerned. Regarding undertaking certificate, which is said to be signed by the petitioner, is found to be not correct, rather misleading, as at the time of taking the said undertaking, the respondent authority acted in their own way to take the said undertaking certificate, and in fact they only wanted voter ID card, but it could not be produced as the same was in process before the authority, and so the respondent asked the petitioner to bring certificate from DC Dimapur, and thereafter the petitioner obtained permanent residential certificate and domicile certificate from DC office Dimapur, Nagaland, which is at annexure F of the writ petition. The other particulars mentioned in the said undertaking certificate has not been verified by the concerned authority, and now they are taking the plea that the petitioner himself submitted that no requisite documents were filed, which is not correct at all. Further, it is to be stated that since the petitioner applied in general category, so question of caste certificate does not arise. It should have been, my lord, it's a typing error. Does not arise, as it was not applicable in case of petitioner, but the respondent wrongly marked against it. My lord will see that the undertaking which has been annexed as annexure 1 to the affidavit in opposition. My lord, the tick marks have been made. What documents could not be produced? On caste certificate also it has been marked, my lord. It does not apply to a general category candidate, my lord. So it can be.
Why don't apply? So caste certificate means what?
My lord, scheduled caste.
Does it say that? Very OBC shall culprit that.
We are general category, my lord. It is there in the.
Caste certificate applicable. He's appeared to. Does it say which certificate didn't produce?
Lord, general, it is already mentioned at page number 24 of the writ petition. In general category, my lord, there is no caste certificate.
Your Lordship, his.
You'll be. We can record your name.
Your Lordship.
Are you CG or CFO now? No.
No, Your Lordship.
And
just
my lord,
assisting
if
counsel.
this order may just be reflected on the delay part. On facts, it has been held that delay in filing of writ petition when relevant.
Yes.
Because of the fact that the petitioners could not come earlier, there would not be justification to penalize them for not having litigated. So, my lord, in this case, the delay was condoned in filing the writ petition. It's a short judgment of the Guwahati High Court.
Yes.
Though it was passed during the time when, my lord, the state of Meghalaya fell within the jurisdiction of Guwahati High Court. This judgment will be binding in my humble submission.
See, the thing is that, but the same cycle of recruitment, If someone has come later and got some relief, yes. Anyway, take down here. The petitioner by way of the instant writ application is before this court with a prayer for a direction to the respondent, some rifles, to accept the requisite documents filed by the petitioner, issued by the appropriate authority for appointment to the post of
Rifleman,
bracket carpenter. Stop. It has been contended it is contended that the rejection of the candidature of the writ petitioner is arbitrary and without any basis, inasmuch as the rejection on the ground that we're the first one that domicile certificate.
My lord, the first one is at page number 27.
So I'm not sure that.
It is contended that the rejection of the candidature of the petitioner is arbitrary and without any basis, inasmuch as the rejection of the candidate.
That the domicile certificate was suspect is unfounded. Is unfounded and is unfounded. Stop. Next paragraph. Ms. P. Agarwal, learned counsel for the petitioner, has drawn attention to this court to Annexure C, to the where's that impugn order?
At page 36.
Yes, to Annexure G at page 36 of the petition, wherein the petitioner was shown not selected as the requisite documents were not found in order. Stop. In this context, he has taken the court to the documents annexed to the petition to show that due verification was also carried out, also obtained from the concerned authorities in Dimapur, Nagaland, to substantiate the fact that where's that? He said that is the fact that the certificate is genuine.
Subdivisional officer, annexure F, page 35.
Substantiate the fact that the certificate issued is genuine. Stop. Next paragraph. MS S. from Thao, learned counsel, advised Dr. N. Muzika for the respondents, has firstly raised objection with regard to the delay in approaching this court, inasmuch as the selection was held in the year of
2017-18.
In the year 2017-18, and that the writ petition has been filed only as late as in 2022. Stop. She further submits that the petitioner, by an undertaking given on 21/8/2018 has also categorically admitted that he could not submit the required documents. Could not submit required documents, and the same must be found in proper order by the Assam Rifle authorities. So, she therefore submits that in view of the delay and the fact that the petitioner had also furnished the undertaking certificate, no case been out in interference, and the petition is liably dismissed. Stop. Next paragraph. I have heard the counsel of the parties examine materials from the record. Firstly, it's noted that the writ petitioner has approached this court after considerable delay and has based his case on the fact that in a subsequent selection which was conducted in 2022, a similarly situated candidate was afforded appointment on papers and documents that were issued by the same authority. Stop. It is further noted that as submitted, the undertaking certificate, which is the next where the certificate has been given by the said candidate who has affixed his signature apart from his thumbprint stamp. In reply, it is seen that in the affidavit in rejoinder filed thereto, it has been stated that the respondent authorities only wanted the voter ID card, which could not be produced as a Siemens process, and on this ground, what the heck? Oh no, sorry. In paragraph 5, oh no.
In reply, the seen that affidavit of the affidavit 5.
On the affidavit file.
It has been stated that the respondent authority only wanted the voter ID, which
could not produce as the same on the process, same process term.
And on this.
Yeah, no, first term. Sorry. Next paragraph. Very important aspect that cannot be overlooked in this instant case is the factum of delay and laches on the part of the writ petitioner, which has not been sufficiently explained. The mere filing of when did you file your legal notice?
Lord, 1st January 2019.
Yes. The mere filing of since 19. The
yes,
mere no.
Then 2021 was.
No, this is 1st January 2018.
No, my lord.
The
is
mere
19.
filing of legal notice can make out. Have you had a type copy of legal notice?
Yes, my lord.
Where is it? See?
Lord, typed copy is at page 40.
You see your date there?
Different dates, my lord.
My lord, typing error, my lord. It is 2019. The writ petition in the averment, it has been made, my lord.
The mere filing of a legal notice, the mere issuance of legal notice.
At the bottom of the legal notice also, it is correctly typed, my lord.
No date's been given, even in the original copy, nothing is there.
In the original, it is there, my lord.
Here, in the one he photostated and...
Yes, my lord.
Has it been
last
received?
Paragraph, page 39.
Where's the factum of that's been received by the authorities?
My lord, that is not with us.
Then?
Because it was not issued by us.
No.
Very important aspect that cannot be overlooked in this instant case on the fact of
It's on the fact of delay and latches. So stop. The mere filing of legal notice some in January 2018 are submitted, which however does not bear any stamp of receipt, will not suffice to clear the defect. Stop. Although a judgment has been placed by the learned counsel for the petitioner with the development of law in regard to with the development of law recently, delay is a crucial factor and is based and condemnation of the same is based on the facts and circumstances of each case. In the present case, there being no sufficient reason for the delay and with undertaking furnished by the writ petitioner, no case made of interference and the writ petition upon stands dismissed. However, no orders to cause. Yes.
Obliged, Lord.
24. 24.
Yes.
Lord, this is a case of remusteration to the post of SKT engineer, storekeeper technical engineer. Lord, in the instant case, the petitioner had entered service with Assam Rifles in the year 2005. Subsequently, my lord, the petitioner was sent for training to Dimapur and Lakhimpur in 2006. Now, my lord, thereafter, after he was posted, after his posting, he was he was posted in Rajasthan in Nagaland for 3 years.
Now he's Havildar.
Yes, my lord.
Yes.
Sorry, my lord. I think he's not yet Havildar.
Is it Havildar also? What he has to be Havildar.
He's Rifleman GD, my lord. He's not Havildar.
Sure.
Rifleman GD. Cause title reflects it, my lord. Rifleman GD. My lord, he was posted at Ghaspani, which is in Nagaland, for 3 years, and at that point of time there was a vacancy for diploma in store management course for class 3 as storekeeper technical engineer, in short SKT. My lord, the company commandant of the petitioner requested the petitioner, asked the petitioner to undergo the said training, and accordingly the petitioner was sent for...
What does SKT means?
Storekeeper technical.
Storekeeper technical, okay. Storekeeper technical. I'm not heard of this trade.
My lord, in fact, the post has been created recently. Though the petitioner has been functioning as storekeeper technical since 2018, but the post has been created recently.
SKT,
storekeeper technical.
Okay, very good.
Now, under SKT also, my lord, there are 2 categories. So, the case of the petitioner is SKT engineer. My lord, so the petitioner was sent for training at Jabalpur for a period of 6 months. That was in 2009 to 2010. And after completing the training, he came back to Manipur, Chandel. And accordingly, a mark sheet was given to him dated 9/4, which is annexed.
But now you say here in the synopsis that he's been serving since 2016.
Yes, my lord.
When did he go for training?
My lord, he went for there are 3 levels of training, my lord, in this. One is the class 3 training. The class 3 training took place between...
No, he was serving. How is he serving against this post?
Yes, my lord. I'm coming to that, my lord.
Yes.
The 3 levels of training are there. The class 3 level of training was completed in 2009-10. The class 2 level training was a 1-month training, which took place from 17/10/2016 to 17/11/2016. After he completed this class 2 engineering training at Shillong, my lord, he was posted at Charidwar, Assam. And in Charidwar, Assam, he started performing his duty as SKT engineer. Though, my lord, the term SKT engineer has not been given to him, or the post has not been given to him directly.
When was this post created then?
It has been created, my lord. The first advertisement was issued in November 2021, but no action was taken. 12/11/2021.
Yes.
But no action was taken thereupon. Subsequently, second advertisement has been issued, which is 15/6/2022, page 39. My lord, the typed copy is at page 40A.
40A.
Yes.
Yeah, this
40A.
branch also applies.
So there were 9 vacancies in the post of SKT engineer. This is when the post has been created, my lord. But the petitioner has been discharging the duties of SKT engineer since the year 2016, as soon as he cleared his class 2.
Now just come to this table that you've made.
This table, my lord.
Eligible criteria for investigation above trades as under name of post store.
Name of post, my lord. Number 1, the
Now,
first
okay,
one.
you come back to the
SKT
second
engineer.
table. Yes, no, come to the second table, store.
Store, my lord. It is not just store, my lord, it is storekeeper technical engineer, and this is the eligibility criteria to be appointed to the post of SKT engineer.
Yes.
Firstly, rifleman with 5 years of regular service, which he has been rendering, my lord.
Yes.
Secondly, must have passed matriculation from a recognized board or university. He has cleared, my lord. Must have passed promotion cadre before final result of remusteration. My lord, in this case, the petitioner has qualified that also, the N cadre. It is called the N cadre. That is also done, my lord. Must have passed map reading standard 2. That is also clear for the petitioner, my lord. Storekeeper technical engineers course from Army or the Central Police Organization institution. That also he is eligible. Medical category must be shape 1. That also, my lord, it has not been disputed. The upper
So
age,
what is your claim? You said that
the ground on which my application is being rejected, my lord, is the upper age limit of 35 years. Now, my lord, this upper age limit has been introduced on 15th of June 2022. It was not there prior to that.
Where is the rejection?
My lord, he had submitted his application and it was recommended by them. Thereafter, my lord, willingness certificate.
No, where is rejected?
My lord, there is not a direct rejection. There is a type. There is a name of candidates who are eligible for remusteration from other trades. So that is at page number 50, and a typed copy is at page 51A. The last page of the writ petition. So in this list of selected candidates, my lord.
These all for storekeeper.
Yes, my lord.
All of them.
These 8. There were 9 vacancies, my lord.
And
so
how many they are?
They are 8.
Where is the list?
Page 51A.
8, 7, 8. Okay.
8, my lord.
Sanjay
But
Kumar
not a single person out of this, my lord. They have cleared the N cadre.
Forget your own case on your own eligibility.
Yes, my lord.
So anyway, so for you,
So
it's only a question of age only.
Yes, my lord. Only the question of age, and that too, my lord. I had completed the examination. I had got certified.
No. How old are you now?
My lord.
As per your affidavit.
Yes, my lord.
36 years.
36 years. So I am 1 year, few months exceeding.
Can the court direct for condemnation of age?
My lord, the reason behind it, my lord. The post was not officially created, but the petitioner has been serving in the post of SKT engineer since 2016.
Yes,
the vacancy was already there. Now, my lord, it is due to the respondent's fault that I have become overaged. They did not create the post because they were getting the service, my lord, from a rifleman GD. So there is no fault of the petitioner in this being overaged. They did not advertise this particular post for all these years, for the past 6 years.
But as per your own submission created in 2022, and this petition filed 22, you were 36 years admittedly at that point of time.
Yes, my
correct?
lord. 36
So as
years.
per the advertisement criteria, you don't qualify.
My lord, the advertisement.
Notwithstanding your excellent qualifications.
My lord, not about just the qualifications. Otherwise also, when I'm serving since the year 2016, the date, my age at that point of time was 30 years of age. So that age has to be taken into consideration, my lord. Since the time I entered, since the time I started.
When was the last training you did in this storekeeper technical?
My lord, 2016, annexure C and C1 at page 20.
Okay.
And typed copy is at page 20A. Class 2. 17th October to 17th November 2016. That is at page 20B.
Okay, you got very good marks also. Yes. Dr. Mosika, can't condone the age.
But what happened, my lord? Even the cutoff date was favorably changed, my lord. It was stated in para 7 affidavit, my lord. The cutoff date was fixed from was counted as on 1st August 22 instead of 1st January. It was supposed to be counted from 1st January, my lord. We extended, we got advantage of 7-8 months, my lord.
That is because, my lord, the advertisement was also delayed. November advertisement was there, then August.
Yes.
Counting from that date, my lord, on the date of eligibility, he was already 36 years, 4 months and 9 days.
He was only 36 years?
4 months, 9 days.
See, one thing, MS Agarwal, court can't issue mandamus for relaxing the criteria.
Then, in that case, my lord, I may be granted a 1 week time. I'll come up with some law on this.
Come up with law, please. Yes, I don't want to dismiss 2 cases in a single day. So,
because, my lord, the respondents have not been advertising the post.
See, who will be culpable for this? It's not that you haven't advertised a post, I'm fit. Doesn't mean that you don't have a vested right. You can't expect the mandamus to see that, yes, I'm fit for the post, advertise it. No, even promotion also, there's no right.
But
So
my
anyway,
age, that is why, my lord, since the day I have been serving as SKT
see,
engineer,
you're
discharging the
eminently
duties.
qualified, yes, there's no doubt about that.
I am discharging the duties also, my lord.
Yes.
Since 2016.
So apart from advertisement, there's no other way for remuneration, Dr. Mosika.
Only 9 posts were sanctioned, my lord. Those it appears and filled up.
All 9
No,
posts
my
filled up
lord.
now.
Only 8 of them have been selected and they are still under training because they do not qualify as per the advertisement requirements.
You don't require any more training.
No, my lord.
You bring authorities only in that point. I don't think it has to be very, very special, or some grievous. You've suffered some grievous harm, whereby by not considering the age, you've been deprived of something which the action of the respondent is worse than any illegality. Yes. After hearing some length, MSP Agarwal, please fill out to produce some authorities on the next date. This is the matter and so on. You satisfy the court. Court's with you, but show me the law.
Yes, my
Take the
lord.
order.
Yes, my lord.
You can't show me the law then.
Indeed, my lord.
Yes.
Obliged, my lord.
Second call, item number 2.
Number 2.
Mr.
Yes.
Contempt proceedings.
Yes, Dr. Mosika, what do you have to say about this?
What happened, my lord? The lordship recollect the other matter, my lord, Dr. Dipankar Chakravarti's matter.
Yes, my lord.
See, this is also a transfer.
This is also transfer. My lord, what happened, my lord? The policy was formulated in 2021, my lord, August 2021. There was serious objection by many of the paramilitary forces to that. The reason for objection being, my lord,
intra-service.
Some of the forces are confined to Northeast, my lord. For example, Assam Rifles, ITBP, my lord. And doctors, what happens? They want to go to cities, my lord, or mainland areas. And the new policy was such, my lord, that Assam Rifles and ITBP especially, no doctors will
be denuded, you mean?
My lord. So we placed objection before the ministry, my lord. And that is under active consideration. The ministry has again called for feedback from all paramilitary forces, my lord. Ministry, this is at advanced level. What I've been told, my lord, of the record, my lord, that this matter has to ultimately go to. It is being examined at the level of additional secretary, my lord, and this will go to home secretary, my lord. We are playing for some more time, maybe 2 to 3 weeks, my lord.
Now when was his transfer order issued?
In this case, my lord.
Was that been issued?
It's a transfer order, lordship. That transfer order was issued on This
the here order is my lord. Only with regard to the policy order.
For quashing the policy or for implementation of the policy?
Non-implementation.
What happened, my lord, when the writ petition was filed, my lord, their grievance was that a new policies would come where specialist GDMOs, my lord, general duty medical officers, if they acquire in-service specialization, they should be treated at par with specialist doctors, my lord. That was the basic case, my lord. To that effect, in 2021, my lord, the ministry considered the matter and came out with a policy, and on the basis of that policy, the matter was disposed of by this lord, by lordship. By holding that, since the petitioner's grievance has been redressed substantially, the matter was closed, my lord. Soon thereafter, my lord, there were complaints against that policy, and the ministry has to re-examine. That is why they have come for contempt, my lord, saying that after the matter.
So that time, after the policy came out, then this petitioner was happy because it became fructuous because only lateral entry, lateral movement. That's the only thing you agreed with. Yes.
Lordship, order of this honorable court is reflected page 26 of my contempt petition, Lordship. And Lordship, it to kindly come to the page 28, letter dated 13 December 2021, and page 30, paragraph 3, clause 1. The MHA new posting policy as mentioned in the para 1 within bracket F has not been implemented in the Assam Rifles till date, as a case for maintaining the status quo has already been forwarded by Sri Ajay Kumar Valla IS, Union Home Secretary of the Government of India, and the decision for which is still awaited. And thereafter kindly come to page 31, paragraph 4, Lordship. In view of the above, you are requested to direct the Composite Hospital CRPF to release the Commandant CMFO Shailendra Kumar for it. That applicant number 1 is on Lordship, that Shailendra Kumar. And Lordship also kindly come to the major point of the order, the 6/7/2023 of this Honorable Court, Lordship. 6/7/2023. In this matter. Yes, Lordship. 7/8/2023, Lordship.
Where, which page?
Lordship, that order that 7/8/2023.
Oh, last order of this
yes,
court.
Lordship.
Yes.
And prior to that 6/7/2023, there is also an order of this court. 6/7/2023.
Yes. For appearance of Home Ministry official.
Yes, Lordship, that Mr. Mozumdar, Learned Counsel for the petitioner, has drawn the attention of this court for the repeated orders.
No, we condone that because
yes, Lordship,
it will be resolved within. It will be resolved within.
Yes.
Now the 7/8, that's the 7th of August.
7/8/2023.
Only yesterday and this morning I got instance. This is under active consideration of Additional Secretary of Ministry.
How can we carry on like this? There's not only one case affecting so many cases. How many petitioners are here?
Lordship, there are 4 petitioners.
They're all doctors.
They all are doctors, Lordship. 5 petitioners, 5 applicants, they all are doctors.
So, but the other doctor is not here. What's his name? The one that.
Which is Dipankar Chakravarti, Lordship. This is an order of this court, Lordship.
That is coming on Thursday. There's slightly different. That's all.
How we prepared for the matter was EDG that will appear personally.
In fact, I spoke to EDG also, my lord. My lord, what he told me that because there are 2 situations, there are 2 policies, my lord. Now, which policy is in place, that even that is not clear.
It's not that. I mean, EDG, you take a call, it's on his head.
Because ADG is what he told me, my lord, that he gets authority only if 21 policies in place, my lord. The 21 policy restructures the entire system, my lord, and ADG is put at the head of that. But if 21 policy is not in place, then forces are independent to transfer their cases. The doctors.
when the teeth of the orders of this court, can you transfer people and allow them to be accommodated? As the orders have to be recalled.
But in fact, I told them in the other matter that
otherwise
that is going to lead to some complications. Even this matter.
What to do, Mr. Das? Yes, Das, no?
Lordship is Bijbura.
Oh, sorry, Mr. Bijbura.
But
This
the
matter,
three- my lord,
can be resolved.
I'll personally take up with them, my lord. 3 weeks time is granted, my lord.
3 weeks time was already granted by this
It was
court, right?
granted
Order
by the-
7/8/2023 to allowing the respondents to resolve the
I
matter.
spoke to them even yesterday and day before
Matter.
yesterday and this morning also, my lord.
Dr. El Mozikas, in spite of his best efforts, he has been informed that the matter is still under active consideration, and he prays that, and he prays that without some further time to allow some further time, the player responds without some further time to resolve the matter as is of far-reaching consequences. Stop. Though this court is averse to granting no more time, but in interest of justice, we just give 2 weeks further time. 2 weeks further time granted. Or we file affidavit, and then we'll have to issue process for contempt. What to do? That's the only thing that will make them wake up and.
What will solve problem? My lord? If 3 weeks time is granted, if you know everybody.
Okay, 3 weeks.
Somebody can appear after 3 weeks. You know everybody's fine.
Yes. Let Mr. Bhalla appear. Let him come to his home cadre and visit after many years.
Second call. Supplementary list item number 1.
Mr. Paul, anything else to submit?
Well, it's only on the issue of jurisdiction. Otherwise, you watch.
Meaning?
Whether alternative remedy would per se bar your lordship's exercise of powers under Article 227. That's I think that is where we were stuck, That's the first hurdle I'll have to cross.
No, but this debt recovery matter, there are many orders that have come, which.
Well, it's because here the only issue is, it's not with regard to a challenge to the certificate. We're only saying, that I should have been heard.
But even against interim orders also, even this kind of orders, so this.
I would just draw your lordship's attention to section 18 of the Act.
Yeah.
I thought, section 18 makes a very interesting read.
Depends on how you read it. Interesting or straightforward.
May I just read section 18, Millets?
Yes.
Bar of jurisdiction, Millets. On and from the appointed day, no court or other authority shall have or be entitled to exercise any jurisdiction, powers or authority except the Supreme Court and the High Court exercising jurisdiction under Articles 226 to 227 of the Constitution in relation to matters specified in section 17.
Yes.
I'll take your lordships to section 17, my lords.
Yes.
Well, section 17 says a tribunal shall exercise on and from the appointed date the jurisdiction, powers and authority to entertain and decide applications from banks and financial institutions for recovery of debts due to such banks and financial institutions. And then the appellate tribunal, subsection 2, millets. Appellate tribunal shall exercise on and from the appointed date the jurisdiction, powers and authority to entertain appeals against any order made or deemed to have been made by a tribunal under this act. So, millets, section 18 would then actually have a bearing, because it is not only a case, millets, where your lordships have held that the powers of the writ court of this honorable court under 226, 227 cannot be taken away. Here the statute itself makes an exception.
Yes.
So once the statute makes an exception, millets, as long as I come within the millets, the parameters set out by your lordships, millets, which are no longer res integra, that just show me Whirlpool, please.
Whirlpool,
millets. Whirlpool, your lordships had crystallized, millets, 3 basic fundamental principles on which, millets, I could come before your lordships under 226, 227.
Yes.
Paragraph.
Paragraph 14 and 15, Malaj. I'm sorry, Malaj, we're just reading this right now. I not have extra copies. I'll just read it out aloud, Malaj.
Yes.
The power to issue prerogative writs under Article 227 of the 226 of the Constitution of India is plenary in nature and is not limited by any other provision of the Constitution. This power can be exercised by the High Courts not only for issuing writs in the nature of habeas corpus mandamus, prohibition, quo warranto, and other certiorari, but for the enforcement of any fundamental rights contained in Part 3 of the Constitution, but also other purposes. Under Article 226 of the Constitution, the High Court, having regard to the facts of a case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed self-imposed certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least 3 contingencies, namely, where the writ petition has been filed for the enforcement of any fundamental rights, or where there has been a violation of the principles of natural justice, or where the order or proceedings are wholly or without jurisdiction, or the virus of the act is challenged. I am on the second principle, because here it is apparent, my lords, that maybe my written statement was closed. Even if the written statement was closed, my lords, the law requires a vested right is created in my favor, my lords, that I am permitted to participate in the proceedings.
Yes.
So, in my humble submission, my lords, this would come within the parameters of an exception to the general rule where your lordships would not exercise jurisdiction under Article 226, 227. Especially keeping in mind, my lords, Section 18. Now, the other judgment, my lords, which your lordships are also aware of, my lords, this is of course a 7-judge constitutional bench judgment. This is Jaya Kumar's case, my lords, I'm sorry, L. Chandrakumar's case.
Give a citation.
My lords, this is AIR 1997, Supreme Court, page 1125, my lords.
Is the
I'm sorry, my lords, we just picked up these books, my lords, while we were preparing it. We have it here, then I can give the book to you.
Actually, doesn't matter.
If your lordships so permit me, my lords, I can just make a compilation after I submit before your lordships. I'll make a compilation just marking out the relevant paragraphs. This constitutional bench, my lords, otherwise just held this because they were talking about 323A and 323B, my lords, under the Constitution, where the tribunals, the power to set up tribunals of the central government is and the state government is there. And the question then came up is whether your lordships would have the power of superintendence under Article 227. So what it was held, my lords, is the power vested in high courts to exercise judicial superintendence over the decisions of all courts and tribunals within the respective jurisdiction is also part of the basic structure of the Constitution. This is because I'm sorry, my lords, this one. This is because a situation where the high courts are divested of all other judicial functions apart from the constitutional interpretation is equally to be avoided. Which is why, my lords, flowing from here, the consistent law, as if your lordships permit, my lords,
But everything is falls on a case-to-case basis.
I'm sorry, my lords?
On a case-to-case basis.
Absolutely.
The discretion is...
Absolutely.
And
which is why, my lords...
As well, now the self-restraint is becoming more pronounced.
No, that is correct, my lords.
A special tribunal is there.
Absolutely, my lords, I bow down.
Like arguing in the other matter. So,
there I'm just the reverse argument.
It works.
But which is why I say, my lords, where I can demonstrate a palpable violation of the principles of natural justice, my lords, then maybe I can come back and invoke your lordship's jurisdiction. Because your lordships would see my prayer is limited to only allowing me to participate in the proceedings. If that,
but the problem is that now they've gone ahead and a final
order has
announcements already come.
My lords.
And so you see that is where everything is merged to that. Whatever illegality has been committed is maybe it's cumulative, and so that is why
that was something that was bothering me also, my lords.
The thing is that if we had come at that stage, before the certificate was issued, then surely I think Mr. Paul, you would have made out a case with regard, to participation and the way your prayers are rejected for filing a statement. Maybe demanded relook But anyway, let's see. Anyway, you give your
I'll just prepare a small compilation, Malaj, because I quite understand, Malaj, because we are also on the same issue, that it's not really only that interim order. It has culminated into some final order. And how do I get past that?
That is...
Because in the garb of these proceedings, Malaj, I cannot make a prayer before your lordships to set aside the main order. That I cannot.
Yes. Only I know you're fighting like firefighting for your client. That's all. These cases are all firefighting. After the fire is broken out,
fire is everywhere.
Yeah.
I bow down.
Right. Yes. Thank you.
Have it day after tomorrow, Malaj. I'll have
again.
It. No further submissions, Malaj. I'll just for the compilation.
After tomorrow.
Only the compilation. I'll just listen.
Lordship was judgment.
Oh yes. Sorry. Yes.
The Lordship, actually, they have an ample scope to hesitate before this appellate tribunal.
Sorry, Mr. Das, I'm very sorry. Yes, please.
Lordship, just I want to give a citation.
Yes.
2016 SCC 569.
2001?
2001.
It's here.
Yeah, it's here.
Yes.
Okay, Lordship.
Is that Punjab National Bank?
Yeah, Punjab National Bank, yes.
Yes. You tried it last time, I think.
Yes, I remember last time. Yes.
Yeah, that is well known.
Lordship.